Chris, this video is just a short one on some of the history of workers' compensation insurance. I'm going to display my screen to you, just a few slides. So we'll start off here with the fact that there's common law defenses by employers originally. What employers would say is they say, look, when this employee came to work here, he assumed a certain amount of risk. So he knew what he was getting into. So I'm not responsible for his injury. Or they could say there's contributory negligence. If the employee contributed in any way towards his own injury, well, then the employer is not totally responsible. The employee himself contributed that negligence. Then the fellow servant rule was just one that says, what if the employer wasn't responsible, but somebody else that he's working with, another employee, contributes to the accident? Well, then the employee has to go over the other employee. He can't go against his employer. So these three defenses of the employer usually kept any employee from being able to make any kind of a claim against his employer. There's other things. Even if an employee did bring suit against his employer, well, the employee would usually be fired. So most cases, you just wouldn't bring a suit against your employer. And then coworkers, even if they saw the accident, they knew that something went wrong, your coworkers, they may have been your friends, but they would be reluctant to testify on your behalf because they too would be fired. And then if you did bring a lawsuit, it could take years to defend, and who has the money to pursue a lawsuit for several years? And then even if the employee did win the lawsuit, the amount of money awarded to the employee usually wasn't adequate to compensate for his losses or even adequate to compensate for his legal defenses. So the legal system just really did not work fairly for the employee. But beginning in the late 1800s in Europe, and it did come through a bit in the early 1900s in the USA, there started to be a recognition of the need for workers' compensation statutes because the system, the legal system, just didn't work well for the employees. Now, in fact, in the US, now all states have required workers' compensation insurance. Texas does not require it. It's the only state that doesn't require workers' compensation, even though they do encourage it, and most companies do carry workers' compensation. It is not required. There's only one case it is required for construction companies in Texas. For construction, they must carry workers' compensation. But the current date, Texas doesn't allow an employee to assert anymore that employees contributed to their injury. So they can't use a contributory negligence defense anymore. They also can't say the employee knew what he was getting into. He knew about the dangers when he came to work here. They can't say the employee assumed the risk of injury and death when he came to work there. And then they also can't use the defense that the injury or death could have been caused by the negligence of a fellow employee. So it's a bit better for the employees, but recognize also with workers' compensation, the employees also, they give up the right to sue their employers, except in extreme court cases such as there's extreme negligence on part of the employer. So that's a brief snapshot of how workers' compensation started. Hope this is of help to you.